Can Elangeni confirm that you have now opened the meeting to the members of the public?
Yes, and we are live now.
Thank you very much. Welcome, members of the public who are joining the Energy Regulator meeting number 250. Can Elangeni confirm that you have now opened the meeting to the members? Ask the members to look at the agenda, the items that we are going to discuss in this open meeting. Items. Can Elangeni confirm that you have now opened the meeting to the members of the public? 6.4. Members, can we adopt the agenda for this? Thank you very much. Welcome, members of the public who are joining the Energy Regulator meeting number 250. Can Elangeni confirm that you have now opened the meeting to the members? Ask the members to look at adopt the agenda. I think Mr. Swanda as well. The items that we are going to discuss in this open meeting. Then go to item number 4, the declaration of interest. The forms are in the board pack, and those who do not have access to the forms in the electronic version, I'm sure can sign them and provide them to Faye as soon as possible. Faye, you would be able to collate these. Ms. Ngube, are you able?
Yes.
Yeah?
Yes.
Thank you. All right, then, colleagues, can we then move to item number 5, the electricity subcommittee? We'll start with the report from the chairperson of the electricity subcommittee, Mr. Gumede. You have the floor.
Good morning again, Chairperson. Good morning, members. Good morning, colleagues. Thank you for the opportunity to present this report, which is a simple report in this case because I'm presenting a report of the subcommittee, and we are here to request the Energy Regulator to note the publication of the consultation paper on the Eskom Retail Tariff Restructuring Plan, which is actually due for a public hearing tomorrow in the morning. We are here just to request the Energy Regulator to note the publication of the consultation paper. Maybe just a few notes on this is that the last approved cost of supply study for Eskom was done in March of 2016, along with then MYPD3 approvals as well, and the revisions on the tariff structure were based on the tariff structure that was done in 2012. On the 5th of August 2022, Eskom submitted a revised RTP for NESA to consider. The RTP consists mostly of the original proposals that were submitted earlier, but also includes new proposals that were not part of the previous plan. Eskom's RTP proposes a number of changes to its what I would like to call consumer price structures, consumer prices, or as it is called, the tariff structures and rates. Proposed changes are based on, firstly, updated tariffs with cost to serve results and the implementation of certain objectives such as pricing signals and effecting subsidies and phasing in of certain changes to minimize impacts of the changes that are happening in the industry. I will skip most of it, Chairperson, assuming that it has been read, and also considering the fact that this report is just here for noting, and the Energy Regulator will have an opportunity to engage with this item once it's been consulted on, and also once the document has served at the ELS, and will come back here for approvals. Chair, but there were a number of issues that I just want to raise, perhaps that the issues that were raised at the ELS meeting of the 6th of September 2022. The first one being the question that was asked, which is what the relationship is between the proposed RTP and the proposed electricity price determination methodology for the electricity supply industry in South Africa. That was the first question that was raised. The second issue is that members raised the fact that the energy regulator should be neutral, when dealing with such applications, and hence, and also I guess linked to that is that the energy regulator is obliged to consider any application that is made by to consider any compliant application that is made by an applicant, and hence this one is being considered. Members commented that the application would require extensive engagement with ELS members and external stakeholders due to the potential impact and far-reaching implications to all electricity consumers. And the hope is that that will indeed be done. Part of it is starting with the public hearing tomorrow, in terms of the public, in terms of the general external stakeholders. And we are hoping, we only have 2 presenters at this stage, but we're hoping that it would be attended broadly. Chairperson has indicated, we just here as the committee to request that the energy regulator note the consultation paper, and to also just request that those that can attend, the members of the regulator who can attend, to also join in at tomorrow's public hearing. Thanks, Chairperson.
Thank you, Mr. Kumete. Members, the item is here for noting, and if you have any questions, concerns, inputs, or enhancements that you would want to get done on the submission, you have the floor. I don't, Mr. Sibanda?
Thank you, Chairperson. Chair, I'm quite happy to note the consultation paper. Chair, just the one thing that I wanted to check with Mr. Gumede, I didn't see a question that talks about the impact of the current restructuring of the electricity industry on the tariff, on this tariff plan, unless I missed it, and perhaps it's something that could be put to the stakeholders during the public hearing, if it's something that's worthwhile. Thank you, Chair. And well, secondly, I also wanted to confirm whether we are still on track regarding the timelines that have been put forward. Thank you, Chair.
Thank you, Mr. Sibanda. Mr. Gumede?
Thanks, Chairperson. We'll start with the easier one. Yes, we are on track in terms of, because the public hearing was scheduled in terms of the plan to be held tomorrow, and it will indeed be held tomorrow. Although we only have two presenters at the stage, and the view is that we'll then have a workshop with members, as indicated. Hopefully on the 4th. I'm not sure whether that's been scheduled, but that's the intention. The workshop should precede an ELS approval of the RFD of the 8th. So with a view that we should be able to have a decision of the energy regulator by the 30th of November. It is an ambitious program, considering the issues and now talking about the first question that you asked about the impact. Yes, the document may not be explicit about it, but in the main document itself, the ESCOM document does talk to those. But the colleagues felt that it was better to ask those broad questions which were put forward in the consultation paper on the 4th, but also to whether we would have had enough engagements with the members that the ELS would then be able to come up with some proposal or recommendation to the ER when it meets on the 8th of November. Thanks, Chair.
Thank you. Thank you, Mr. Kumete. Mr. Sibanda, can we take it that your questions have been addressed? And may I, by the show of hands, then see if we are in support of noting this, regulator members? Good, Mr. Kumete, Ms. Mpungose, Ms. Sibanda, Ms. Maseti, Advocate Tole. Ms. Bia and Ms. Simani. Thank you. The regulator notes this submission. Colleagues, we are then going to move to the next item, I think item number 6, which is the report from the chairperson of the piped gas. We'll start with the 6.1. Ms. Masetti, you have the floor.
Thank you, Chairperson, for the opportunity to present the work of the Pipe Gas Subcommittee. The first report, Chairperson, is the report relating to the proposal that was submitted by Sasol Gas, which is the licensee, requesting that NERSA monitors and confirm whether the price that it has calculated, whether that price is in line with the decision that was taken by the energy regulator in 2020. So I'd like to emphasize that this was not an official application by Sasol Gas to come up with a price as expected in terms of Section 21(1)(p), but because the price was already approved in 2020 and that price was 68 rands, 68 rands 39, and Sasol calculated now for 2022-2023 a price of about 131. That would have meant that there is an increase of over 90%, and Sasol wanted NERSA to confirm that such price of 131 is still in line with the decision, and they calculated it because they wanted to adjust the price now for 2022-2023. So we acted swiftly to stop that increase because it's quite excessive, and we were also of the view that it would not be in line with the decision, of which decision did not anticipate economic data that could result in almost 100% price increase. So, Chairperson, having engaged with Sasol this far, and also looking at the second part of the decision, which allowed for an adjustment, we have come to a sort of an understanding that NERSA will have to prevent this increase by settling the High Court review application that was brought by IGWASA, only on the second part of the decision that requires an adjustment, not the price, the maximum price of 68 rands, because we believe that such price is reasonable. Only the adjustment, the reason the adjustment will need to be set aside is because it is an adjustment that tracks the price of gas using an international benchmark. At the time, that international benchmark was competitive, but because of the crisis, the benchmark now will result in almost 200% increase. And that is why we say that in order to prevent this situation, we need that aspect of the decision to be set aside. And Sasol also understood that. And all of the other parties were sort of comfortable just to regarding that part of the adjustment of the decision. And Chairperson, we have had some engagement with Sasol Gas, and there is a process in the High Court, and I think the legal services can fill the energy regulator if there are any other questions of clarity with regards to the status of the High Court review application. I would like to stop here, Chairperson, and just to also refer you to paragraph 5.5. That is where the price of Sasol and other traders is recorded on that table. And then other paragraphs there are showing the decision of the energy regulator. If you refer to paragraph 6, and then paragraph 6.28, it shows then what would have been the cost price difference if we were to allow such an adjustment. With that, Chairperson, I would like the energy regulator to note the proposal and also approve that in order to prevent excessive pricing, that the pipe gas subcommittee continues to engage the parties and also to make sure that there is no adverse, at least finding, that will impact the industry negatively. Thank you, Chair.
Thank you, Ms. Masete. Thank you for the brief. Members, any questions, comments, or enhancements to this submission? I'll start with Mr. Gumet and then come to you, Mr. Sibanda. Thank you.
Thank you, Chairperson. Ordinarily, I'm a member of the subcommittee, Chair, and I would have had an opportunity, I guess, to have asked the questions. I've got an extensive number of questions on this, but I'm actually just noting that it is the report is actually here for noting, Chair, and so perhaps maybe not ask these questions in this forum, but rather to actually send it. If the request is that the energy regulator has requested to allow the members of the committee to also continue to engage on this matter, that maybe those issues I can raise at the appropriate platform. But Chair, I've got extensive questions on this, so I don't know, Chair. I was just seeking guidance whether I could go ahead and ask the questions, or should I therefore maybe considering the request by the chairperson of the committee that this matter that the committee be given opportunity to further engage on this, that maybe those questions I can ask at that in that platform. Your guidance, Chair.
Mr. Gumede, maybe we can put the questions on the table so that all of the other members can be aware of them. Whether the response and how they are dealt with will be at the committee is what we'll decide after we have got the questions.
Thank you, Chair. All right, I'll go through them as they appear. I'll start with I had a comment on paragraph 5.3. Chair, and my paragraph and questions and the question that I have is, and I'll put it this way: is this the language of the Gas Act or the language of the Competition Act? Chair, I am sometimes a bit concerned that in how we perhaps regulating the in terms of how we implement our law, sometimes is that we perhaps bring aspects of other laws that I'm not sure on what basis, because if our act does not empower us to actually include any aspect from any other law in considering our law, is question that I ask myself whether do we even have the powers to talk about whatever competitive prices or whatever, or is ours about regulating those prices in a manner that is best suitable for the market in respect of, but using the prescripts of what is in our act. So the question I ask around 5.3 is that in respect of how that one is phrased, is that in line with our law, the law that we administer, or is that in line with the Competition Act? That's the first question under 5.3. The next question, Chairperson, is well, I had a question that I have under paragraph 6.6. And I just had a question there that says the statement that is put there under paragraph 6.6, is that true? And then under 6.7, I had a question that says, why did we deem it fit to adopt this particular approach, the competitive benchmark approach? Perhaps for some of us that came in late with in terms of the regulator, perhaps it might be useful to understand, because in terms of regulation, You know, in other regulators, whether it's liquid fuels regulation and others, it's really about, it's largely cost plus as the basis. Whether that plus is based on a return or based on a margin that is a percentage or whatever, but it's largely cost plus. And depending on those costs, how those costs are recognized. But why did we decide to adopt this competitive approach in respect of the Gas Act? And to what extent is it really entirely consistent with the requirement of the Gas Act itself, or even in terms of that constitution? So that was the question. And linked to that, I think for me, the question is, how does this pricing approach for me promote investments in local gas production or even in LNG infrastructure investment? How does it promote it? And the fact that you are benchmarking against what happens in in Asia, Southeast Asia, and places, or even in the UK, or even happening in the US in terms of the Henry Hub, the circumstances are very different there. How does it promote our local situation? So that's the link to that question. The next question, Chairperson, coming out of paragraph 6.16. I had a question there that says, are we saying that we set the maximum price that does not have to be complied with? Should the tariffs or the prices we set not be cost reflective anyway? So that was the question that I placed on paragraph 6.16. On paragraph 6.19, I thought it would be useful that when we make, like when we say something like, in terms of section 4 of the methodology, NERSA should conduct tests to ensure that it's calculated as, in terms of the maximum prices prescribed, it meets the requirements. It might be useful to just list those requirements in the same document, so that for the easy read, if you say it meets those requirements, the question that arises in one set is which are, and we could tabulate them. Well, that's basically just put them up in a bullet form, so that it's quite clear what is it that we are talking about. Chair, thanks for your indulgence. I'm coming to an end. I think, Chair, as I started earlier, based on paragraph 6.31, I really just have this concern that does NERSA regulate the gas price in terms of the Gas Act or in terms of the Competitions Act? So for me, the reference to the Competitions Act in our decision, is it not going to look like it's an overreach, or is it not ultra-virus in terms of our powers? Just a question, Chair. I'm a bit concerned around this. Linked to that is, for instance, in paragraph 6.31, there's a definition of excessive price. The question I'm asking myself is that if this excessive price is defined in the law that we do not administer, even if they do breach that excessive price definition in the Competitions Act, what powers do we have anyway as the energy regulator to enforce this? Or would we then require that the competition authorities deal with this matter? So the question we ask is that, yes, we may use another definition from somewhere and find somebody to be not compliant. But the question that then arises in my head, then what? What can we do about that? Paragraph 6.36, Chair, I was a bit concerned about, well, I guess we actually, as we say, we do not agree. But the point is, if there's a matter that is likely going to affect the public, I think Sasol would be wrong to say we don't need to actually. Section 10 of NERA and also Section 33 of the Constitution is very clear on that if there's a decision and administrative action that may affect other parties, those parties have got the right to be heard. So to what extent, would Sasol make that statement? The last comment, Chair, which is, I guess, the more fundamental one for me here, is one that says, If we were to, and it comes out of paragraph 8.1, those options. To what extent, Chairperson, can we have any settlement that is not published, predicated on a published methodology? Can we have any settlement which is ad hoc, which is not based on a published methodology? I think we all know on the electricity side, we just had a similar issue with the judge, because we were supposed to, for us to then require an applicant to make an application on a methodology that has not been adopted, was found to be incorrect, and rightfully so. Are we not doing the same thing here? Chair, those are my comments. Thanks.
Thank you, Mr. Commander. Mr. Maseti, I'm sure you've noted them, and as I said, we'll decide whether, I think there are some that you would want to respond to, and there are others that you would postpone to your meeting. So as we get comments from Mr. Sibanda, if you could prepare what you are going to address now and what you will put into the PGS committee. Mr. Sibanda?
Thank you, Chairperson, and thank you to Ms. Maseti for the submission. Chair, my question basically is around the alternative that we are considering, and that's on paragraph, from paragraph 8.1, which I think should be 7 actually, in terms of the numbering. But in any case, in the recommendations, we sort of have taken A and B, but if you look at paragraph 8.2, there appears to be a third option that we have not included in the recommendations. So I wanted to find out whether there's a particular reason why we aren't considering that as part of the substantive recommendations that we are making. And then secondly, we do make mention of, obviously, of the High Court processes, but I wanted to find out whether the Sasol maximum prices have been challenged in other forums, such as the Competition Commission or Tribunal, and if so, what is our involvement? What is our engagement? Because we seem to be having these or recommending these negotiations. So I just wanted to check whether if there is a challenge at the competition authorities, whether we are actually engaged in those as well. And then for me, the other issue is, well, we are saying that because we are not happy with the proposed maximum prices, we sort of, like I saying, then we'll let the current prices continue. But my concern is are those prices not the very same prices that are the subject of a court challenge? And so if you're letting those to continue, what then are the implications? Chair, I think for me those are my questions. Thank you, Chair.
Thank you, Mr. Sibanda. Ms. Maseti, I would want to leave it to you, and the
methodology. So I'll request my colleague to allow us to, and we will also have a workshop again just before we take the decision on the revised methodology, which is a process that we are busy with, so that some of those questions can be dealt with in that forum. So there are specific questions that we can respond to. I sent my colleague a note because my board pad crashed a bit. So with regards to the the use of the international benchmark, I think that is an acceptable international approach, and it was also confirmed by the Constitutional Court in its judgment that, especially in a market where you have a monopolist, what is the method that you are going to use there so that the price that you come up with is a competitive price. By the way, the issue of the competitive price was also confirmed in court because as to in terms of our mandate as a regulator, the regulator regulates those prices must mimic competitive outcomes. That is the role of the regulator. So the only mandate that we are given here is price regulation. And that price regulation is in section 21(1)(p). So it states clearly that we can only regulate prices or exercise our control over price adequate as defined in the Competition Act. So the issue of the Competition Act and the state of competition in the market and the standard that we must apply to assess whether competition is brought in that section 21(1)(p) of the Gas Act, which requires us to make reference if competition in the gas act in the gas industry is not adequate as contemplated 3 of the Competition Act. That is why we have to apply that standard in our assessment of the state of competition in the market. So it means that when we apply our mandate of price regulation, let us first deal with that hurdle of whether competition is adequate or not. And therefore, and this has been argued even in the High Court and Supreme Court of Appeal and then in the Constitutional Court that the price, therefore, that the energy regulator must come up with must mimic competition. It means the competitive conditions that would have happened in a market that is not a monopoly, a market that is competitive. Hence, therefore, when we come up, must be able to come up with a competitive benchmark, price benchmark. So hence, in the first place, come up with a sort of a methodology that will seek to put us, or at least our decision to be seen to be one that will fall within a competitive level. So that the decisions came to a competitive level, the price was 68 rands. And if you look at the cost price difference at the time, and I refer you to paragraph 6.28, you will see that with the 68 rands, which was the maximum, and the cost that were reflected, which I will not disclose, which were reflected in paragraph 6.28, look at that cost and look at the maximum. Then you will see that the difference and what the Constitutional Court terms as economic surplus, you will see that it is quite reasonable. Hence, therefore, for purposes of what is before us, we are saying that the first part of the decision, which in any event has been implemented and up until June 2022, that has been gone. And even the party that took us to court had stated in April of 2022 that that price can remain. And in any event, that price is what is the maximum price. It doesn't change. It can only be adjusted for fairness if costs have increased, and also maybe there was a sort of another competitive condition that would have necessitated the price to change. Only on those two bases that the price of 68 rand would have been tampered with just to accommodate cost increase as well as any competitive condition. So, Chairperson, I don't want to touch on all of that, but I think the summary that I've given and also bring the matter back to what is before us, I think I've clarified some of the questions from my colleague, Mr. Gumede, and I would like to respond to some of them outside of the ER meeting, perhaps at the PGS meeting. But if there is another specific question that I have not touched on, I will request that Mr. Ngumalo or Mr. Makota just come in and respond to that. And the issue of the excessive pricing, Mr. Gumede, we have the mandate. It is specifically mentioned in Section 31 of the Gas Act, where we are required to investigate complaints of excessive pricing. In the same way that the competition authorities are given powers to investigate excessive excessive pricing in terms of Section 8A of the Competition Act. So in that regard, for that purpose, we've got concurrent powers when it comes to investigation of excessive pricing, and would not adopt different standards because of purposes of ensuring that the policy administration or implementation is not sort of misaligned. And I think Section 21K or H of the Competition Act states clearly that it must be managed, that concurrent powers, in a harmonized manner. So the governing statement there, when it comes to those competition issues, are already stated in that act, so that because we are all bodies, government institutions that must implement policy in a harmonized manner. So it's very important that we do so. I take the point, Mr. Gumede, with regards to the consultations, as that will be consistent with Section 10 of the National Energy Act and the Gas Act. Coming to the issue of the methodology there, obviously this one, the methodology, we've got rationality test, and the issue of rationality was raised by the Constitutional Court, hence we incorporated it in the methodology in the first place. So even if there is a settlement, that settlement, it is only meant to...
There's a question that Mr. Gumede asked around that would you have a settlement based on an ad hoc methodology that's not been published? Could you just address that?
Chairperson, that is not an intention at this stage, Chairperson. The current methodology has not been repealed, and the current methodology has cost consideration under Section 4, which Section 4 deals with the rationality test. That rationality test, which is something that Sasol has not considered when it came up with that proposal of 131 per gigajoule. And that was also clearly articulated to Sasol and its legal team, and they took the point and understood exactly what the energy regulator is concerned. We cannot accept a situation where it will just come up with a price when they have not demonstrated how that price level compares to the cost, so that we can see whether or not the difference is at a reasonable level or is at excessive levels. So that was the issue, and Sasol accepted that, including its legal team, and on that issue when it was explained. So that is all covered in the current methodology under rationality test, Chairperson. So it will still be considered on that. Thank you, Chair.
Thank you, Ms. Maseta. The other one, I think, just before we move to Mr. Svander's question, statement 6.6. I think the question was it true? Is that statement true? And I'm sure you can express a view there.
6.6.
Am I quoting the right section, Mr. Gumede? I think it was 6.6.
If it's 6.6. Mr. Gumede can assist us so that I make sure that I go straight to the answer there, the essence of the question. I think Ms. Magwada says it's paragraph 6.16.
6.16. That's the paragraph, if I may assist things.
6.16
is 616.
I think maybe that statement may need to be rephrased. It's not necessarily incorrect, but I think it will need to be rephrased, Chairperson. So what it means is that even though you may use an international benchmark because you're trying to find a competitive price level, even if you were to do so, what they are meaning there is that you cannot ignore or disregard. That is correct in the way that also from our side, it is important that you consider the cost, because you can't have a price that will be at 108 mark according to other competitive markets, but do not do that with cost. Need some rephrasing there so that it reflects what
Mr. Gumede, are you fine with the other ones that we are shifting? Quick clarity around whether it's in the Act or not. Are you comfortable with what has been given?
President, thank you for the opportunity. And yes, I am addressed. And and dealt with at the PGS, but I am covered. But the question you are asking, Chair, is actually it is paragraph.
Chairperson, our questions from Mr. Sibanda, the one regarding whether the maximum prices for Sasol were challenged in other forums. Yes, they were challenged in other forums. IGWASA has submitted a complaint before the Competition Commission. And because they've submitted a complaint, and that complaint arises because there was a threat of an excessive price increase in August of this year, of which price increase NERSA addressed it and issued a statement and also engaged with Sasol and other stakeholders, and we prevented that price increase. And those responses are now before the tribunal, and the hearing date, I think, of this week, 24th of October. There was a pre-hearing before the competition, GWASA, and then I think the other by Egoli Gas, and they were going to be combined, those matters. Hearing they just dealt with logistical issues as to when of answering affidavits as well as replying affidavits, that, and also the heads of arguments, the affidavits, that, and also the heads of arguments, the dates when those must be so filed. It's a response.